Okay. Hello students, welcome back to Varanda Race Institute. Here at Varanda Race Institute, we provide coaching for those competitive exams like PC, PSI, FDA, SDA, VAO, PDO, Group C and banking examinations as well. And KPSC students, very important news for you. Already KPSC batch classroom coaching session in Varanda Race Institute is going on, meaning it is started just 2-3 days back, which is still in its orientation stage. Still it is not too late for you people. You can still join us and you can enjoy the benefit of scholarship, 15,000 scholarship and also discount on fee structure. KPSC students, the link will be in the description. Don't forget, forward it to your friends also. If you got any doubts regarding KPSC exam, do contact us. Do talk to our mentors and counselors. They will guide you and they will give you good vision. Radha ma'am, namaste. Jyoti ma'am, good evening. Basul LK, hello sir. Hello, namaste. So students, in our previous class, we learnt about Article 20 and 21. In this class, we are learning about Article 21A and 22. Indian Constitution, Bharata ಸಂವಿಧಾನದ ಆರ್ಟಿಕಲ್ 21A ಹಾಗೂ 22 ಇವತ್ತು ನಾವು ಕಲಿತಾ ಇದ್ವಿ. We are learning Article 21A and 22. So, what is the title? What is the title or name? What does Article 21A talks about is right to education. Right to education, Article 21A. Students, if you have already learned DPSP students, there is already under DPSP, Directive Principles of State Policy ಕೆಳಗಡೆ Article 45, DPSP Article 45, under DPSP Article 45, already there is given provision for free and compulsory education for children 6 to 14 years. Already there was a provision when Constitution was drafted. Jyoti ma'am, right to education, yes. 1950, 26 January 1950, when the Constitution commenced, already there was a provision under Directive Principles of State Policy, Article 45, free and compulsory education for children between age group of 16-14 years. But we know students, DPSP is not enforceable. DPSP is not enforceable in any court of law. If the articles under DPSP is not enforceable, then how will the citizens of India enjoy the benefit? Houdalva? DPSP ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಿಲ್ಲ ಅಂತ ನೀವು ಯಾವುದೇ ಕಾರಣಕ್ಕೂ ಕೋರ್ಟ್ನ ಕದ ತಟ್ಟವಾಗಿಲ್ಲ. DPSP are non-enforceable. To make it enforceable, the right to education Article 21A was added to the Indian Constitution, by 86th Constitution Amendment Act 2002. 86th Constitution Amendment Act, Article 21A was added to Indian Constitution. That is right to education. Right to education for whom? Right to education for children who are between 6 to 14 years. And the DPSP Article 45, there it was changed that under Article 45, under Directive Principle DPSP under Article 45, the education is for children who are between 0 to 6 years. But under Article 21A, free and compulsory education is for 6 to 14 years. Under DPSP under Article 45, free and compulsory education is for children who are between 0 to 6 years. So, as I told you, ನಾನು ನಿಮ್ಗೆ ಹೇಳಿದೆ 86ನೇ ತಿದ್ದುಪಡಿ 2002ರಲ್ಲಿ Article 21A ಆ್ಯಡ್ ಆಗಿರೋದು. Article 21A was added in 2002 by 86th Constitution Amendment Act. Before that what happened? ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಏನಾಯ್ತಪ್ಪ ಅಂದರೆ 1992, 1992. In 1992, Supreme Court gave a verdict telling that fundamental right to free education up to any level up to any level. See here, 86th Constitution Amendment Act 2002 gave age for 16 to 14 years. 14 years means you will be in 9th standard, right? 9ನೇ ತರಗತಿಯಲ್ಲಿ ಓದ್ತಿರ್ತೀರಾ ಅಲ್ವಾ? 14 ವರ್ಷ ತುಂಬಿರುತ್ತೆ ನಿಮಗೆ, 9ನೇ ತರಗತಿವರೆಗೂ ಓದ್ತಿರ್ತೀರಾ. Article 21A is giving fundamental right for free and compulsory education till 14 years. But before that, in 1992 Supreme Court gave verdict that free and compulsory education up to any level, even including engineering, including MBBS, state Indian government should give you free education up to engineering, up to MBBS level. The 1992 Supreme Court verdict had given up to any level. ಬರೀ 6ರಿಂದ 14 ವರ್ಷದವರೆಗೂ ಮಾತ್ರ ಅಲ್ಲ, ಇಂಜಿನಿಯರಿಂಗ್ ಓದೋವರೆಗೂ, ವಿದ್ಯಾರ್ಥಿ ಇಂಜಿನಿಯರಿಂಗ್ ಓದೋವರೆಗೂ, MBBS ಡಾಕ್ಟರ್ ಆಗೋವರೆಗೂ ಫ್ರೀ ಎಜುಕೇಷನ್ ಕೊಡಬೇಕಂತ 1992ರಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆದೇಶ ನೀಡಿತ್ತು. ಬಟ್ ಲೇಟರ್ ನೆಕ್ಸ್ಟ್ ಇಯರ್ in 1993 again Supreme Court will change its verdicts. 1993ರಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ತನ್ನ ವರ್ಡಿಕ್ಟ್ ಅನ್ನು ಬದಲಾಯಿಸಿಕೊಳ್ತದೆ. ಏನಂತ ಅಂದ್ರೆ, fundamental right to free education only until 14 years. Thereafter, it is the subject to limit of economic capacity of the development of the state. Understanding students? In 1992, 1992ರಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಏನಂತ ಆದೇಶ ಕೊಟ್ಟಿರುತ್ತೆ ಅಂದ್ರೆ, ಅಪ್ ಟು ಎನಿ ಲೆವೆಲ್ ಫ್ರೀ ಅಂಡ್ ಕಂಪಲ್ಸರಿ ಎಜುಕೇಶನ್ ಅಪ್ ಟು ಎನಿ ಲೆವೆಲ್ ಇನ್ಕ್ಲೂಡಿಂಗ್ ಎಂಜಿನಿಯರಿಂಗ್ ಅಂಡ್ MBBS also. But in 1993, giving free and compulsory education up to engineering and MBBS level is very costly. ಸರ್ಕಾರಕ್ಕೆ ದುಡ್ಡು ಬೇಕಲ್ವಾ, ಎಲ್ಲರಿಗೂ ಅಷ್ಟು ಎಜುಕೇಷನ್ ಫ್ರೀಯಾಗಿ ಕೊಡಬೇಕಂದ್ರೆ. ಸೊ in 1993 up to any level was deleted and it was made till 14 years. The state should give compulsory free education up to 14 years. After 14 years, it is depending on the capacity of the state. So this same 14 years was adopted under 86th Constitution Amendment Act 2002, which is giving free education for 6 to 14 years. When 86th Constitution Amendment Act 2002 was introduced, the subject matter of DPSP changed. After 86th Constitution Amendment Act 2002, under Article 45, under DPSP, under Article 45, the free and compulsory education is for 0 to 6 years children. But under Article 21A, free and compulsory fundamental right education is for 6 to 14 years. I hope you are understanding. ಅರ್ಥ ಆಗ್ತಿದೆ ಅನ್ಕೊಂಡಿದ್ದೀನಿ ಸ್ಟೂಡೆಂಟ್ಸ್. So let's see what is 86th Amendment of Indian Constitution. 86ನೇ ತಿದ್ದುಪಡಿ ಭಾರತ ಸಂವಿಧಾನ 2002. Let's see what it did. So 86th Constitution Amendment Act 2002 added the Article 21A. ನಾನು ಆಗಲೇ ಹೇಳಿದೆ 21A ಆರ್ಟಿಕಲ್ ಇನ್ ದ ಸಂವಿಧಾನ ಜಾರಿ ಆಗಿರೋದು 26 ಜನವರಿ 1950. 26 January 1950 Indian Constitution commenced. Till 2002 there was no fundamental right for free and compulsory education. ವಿದ್ಯಾರ್ಥಿಗಳೇ ದಯವಿಟ್ಟು ತಿಳ್ಕೊಳ್ಳಿ, 2002ರವರೆಗೂ 86ನೇ ತಿದ್ದುಪಡಿ 2002ನೇವರೆಗೂ ಯಾವುದೇ ಥರ ಮೂಲಭೂತ ಹಕ್ಕು ಇರಲಿಲ್ಲ ಫ್ರೀ ಆ್ಯಂಡ್ ಕಂಪಲ್ಸರಿ ಎಜುಕೇಷನ್ಗೆ ಮಕ್ಕಳಿಗೆ. Only in 2002, 86th Constitution Amendment was introduced and Article 21A was introduced, which guarantees free and compulsory education for children aged 6 to 14 years. Aged 6 to 14 years. Under Article 5 DPSP, the free and compulsory education is for 0 to 6 years. Under 21A, Article 21A, fundamental right, the free and compulsory education is between 6 to 14 years. So when 21A article was introduced under 86th Amendment Act 2002, the subject matter, Article 45 was modified. Article 45 was modified, telling that Article 45 will give free and compulsory education under 6 years, 0 to 6. Article 45, 0 to 6. free and compulsory education for children. Article 21A, 6 to 14 years. Please understand. I hope you are understanding. So what was 86th Constitution Amendment Act 2002 was called as dawn of the second revolution. Please note it down. 86ನೇ ಸಂವಿಧಾನದ ತಿದ್ದುಪಡಿ 2002 86ನೇ ಸಂವಿಧಾನ ತಿದ್ದುಪಡಿಯನ್ನು ಏನಂತ ಕರೆಯಲಾಗಿದೆ ಎಂದರೆ dawn of second revolution. It is called as dawn of second revolution. Dawn, DAWAN, dawn of second revolution. I hope you are understanding, students. Now, we all know, students, in India, right to education, RTE Act, right to education, right to compulsory free and compulsory education, right to education, RTE Act 2009 was introduced. RTE Act 2009 was introduced, where even in private schools, some seats should be given under RTE Act to the poor students. That is, in pursuance of Article 21, Parliament enacted right of children for free and compulsory education. That is RTE Act 2009. Sanhok, 11th fundamental duty added also. Yes sir, correct. Super Sanhok, super. Sanhok, very good. Students, when fundamental duties when it was added through 42nd Constitution Amendment Act 1976, there were only 10 fundamental duties, students. There were only 10 fundamental duties recommended by Sardar Swaran Singh. Sardar Swaran Singh committee during Indira Gandhi will be our PM, Iron Lady Indira Gandhi ji. During Indira Gandhi ji, when she is a prime minister, Sardar Swaran Singh committee recommended fundamental duties. There were 10 fundamental duties which was added to the Indian Constitution through 42nd Constitution Amendment Act 1976. When Constitution was commenced during 26th January 1950, there was no fundamental duties. Fundamental duties were added in 1976 through 42nd Constitution Amendment Act. There were 10 fundamental duties. 11th fundamental duty was added. When 11th fundamental duty was added? During 86th Constitution Amendment Act 2002. This is only. It is the duty of parents to give children free and compulsory education up to the age of 14 years. Understood? Amrita Patil, hi ma'am. Sanhok sir, I hope you understood. So, in pursuance of Article 21A only, Parliament enacted right to children for free and compulsory education, RTE Act 2019. What is RTE Act means? Even private schools, already government schools, they are giving free seats, reservations for poor students. In private schools also, in private rich schools also, there are number of seats which has to be given as reserved seats for poor students. RTE Act ಅಂದ್ರೆ ಏನಂತ ಅಂದ್ರೆ ಖಾಸಗಿ ಪ್ರೈವೇಟ್ ಸ್ಕೂಲ್ಸ್ಗಳಲ್ಲಿ ಕೂಡ ಸ್ವಲ್ಪ ಸೀಟ್ಸ್ಗಳನ್ನು RTE Act ಅಂಡರಲ್ಲಿ ರಿಸರ್ವ್ಡ್ ಆಗಿ ಕೊಡಬೇಕಾಗುತ್ತೆ ಹಿಂದುಳಿದ ವರ್ಗದವರಿಗೆ, ಆರ್ಥಿಕ ಪರಿಸ್ಥಿತಿ ಕೆಟ್ಟಿರೋರಿಗೆ. ಐ ಹೋಪ್ ಯು ಆರ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಿಂಗ್. Sanhok, clear sir. Okay, Sanhok. I hope you understand Article 21A. ರಾಧಾ ಮ್ಯಾಮ್, MCQ ಕ್ವಶನ್ಸ್ ಇಂಗ್ಲಿಷ್ ವಿತ್ ಕನ್ನಡದಲ್ಲೂ ಕೇಳಿ. ಓಕೆ ಮ್ಯಾಮ್, ಓಕೆ. ಅದಕ್ಕೆ ಇವತ್ತು ನಾನು MCQsನ ಬಾಯಲ್ಲೇ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಯಾವುದೇ ಥರ MCQs ತಂದಿಲ್ಲ, ನಾನು ಬಾಯಲ್ಲೇ ಕೇಳ್ತೀನಿ. ಐ ಹೋಪ್ ಯು ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ವಾಟ್ ಈಸ್ Article 21A. Article 21A, it is right to education. Article 21A. Why Article 21A was introduced? Because DPSP is not enforceable. Under DPSP, there is Article 45 which provides free and compulsory education for students, but the DPSP is not enforceable. That is why in 2002 through 86th Constitutional Amendment, Article 21A was introduced. DPSP, Directive Principles of State Policy, ಆರ್ಟಿಕಲ್ 45 ಕೆಳಗಡೆ ಏನಿರುತ್ತೆ, ಕಂಪಲ್ಸರಿ ಎಜುಕೇಷನ್, ಫ್ರೀ ಆ್ಯಂಡ್ ಕಂಪಲ್ಸರಿ ಎಜುಕೇಷನ್ ಫಾರ್ ಚಿಲ್ಡ್ರನ್, ಅದು ಯಾವುದೇ ಥರ ಎನ್ಫೋರ್ಸೇಬಲ್ ಅಲ್ಲ. ಕೋರ್ಟಲ್ಲಿ ಯಾವುದೇ ಥರ ಅದು ಕೇಸ್ ನಡೆಯೋದಿಲ್ಲ. ಅದಕ್ಕಾಗಿ ನಿಮಗೆ ಒಂದು ಮೂಲಭೂತ ಹಕ್ಕುಗಳನ್ನು ಕೊಡುವುದಕ್ಕಾಗಿ 2002ರಲ್ಲಿ 86ನೇ ತಿದ್ದುಪಡಿ ಮಾಡಿ 21A ಆರ್ಟಿಕಲ್ ಇಂಟ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಭಾರತ ಸಂವಿಧಾನದಲ್ಲಿ ನಿಮಗೆ ಫ್ರೀ ಕಂಪಲ್ಸರಿ ಎಜುಕೇಷನ್, ಫ್ರೀ ಆ್ಯಂಡ್ ಕಂಪಲ್ಸರಿ ಎಜುಕೇಷನ್ ಫಾರ್ ಚಿಲ್ಡ್ರನ್ ಬಿಟ್ವೀನ್ ಏಜ್ ಗ್ರೂಪ್ 6ರಿಂದ 14 ವರ್ಷ, ಬಿಟ್ವೀನ್ 6 to 14 years, free and compulsory education under Article 21A, and it also changed the subject matter of Article 45. Under Article 45, free and compulsory education from 0 to 6 years. Under Article 21A, fundamental right, 6 to 14 years. So in 1992, Supreme Court had given verdict that free and compulsory education up to any level, including engineering and MBBS level, medicine level. But later, same Supreme Court in 1993, it changed its verdict. MBBS ವರ್ಗೂ ಇಂಜಿನಿಯರಿಂಗ್ ವರ್ಗೂ ಸರ್ಕಾರನೇ ವಿದ್ಯಾರ್ಥಿಗಳನ್ನ ಓದಿಸೋದಕ್ಕೆ ಅದರ ಹತ್ರ ದುಡ್ಡಿಲ್ಲ. ಅದಕ್ಕಾಗಿ ಇಟ್ ಚೇಂಜ್ ದ ಲಿಮಿಟ್ ಟಿಲ್ 14 years. 14 ವರ್ಷದವರೆಗೂ ಸರ್ಕಾರ ಮಕ್ಕಳಿಗೆ ಫ್ರೀ ಆ್ಯಂಡ್ ಕಂಪಲ್ಸರಿ ಎಜುಕೇಷನ್ ಕೊಡುತ್ತದೆ. ಅದಾದ ನಂತರ ಇಟ್ ಈಸ್ ಅಪ್ ಟು ದ ಕೆಪಾಸಿಟಿ ಆಫ್ ದ ಸ್ಟೇಟ್. ಇಟ್ ಈಸ್ ಅಪ್ ಟು ದ ಕೆಪಾಸಿಟಿ ಆಫ್ ದ ಸ್ಟೇಟ್. ಸೊ ಲೇಟರ್ 2002, ಲೇಟರ್ ಥ್ರೂ 86th ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅಮೆಂಡ್ಮೆಂಟ್ 2002, 86ನೇ ಸಂವಿಧಾನದ ತಿದ್ದುಪಡಿ 2002ರಲ್ಲಿ ಆರ್ಟಿಕಲ್ 21A ಮೂಲಭೂತ ಹಕ್ಕುಗಳ ಕೆಳಗಡೆ ಅಂಡರ್ ಫಂಡಮೆಂಟಲ್ ರೈಟ್ಸ್, Article 21A was introduced through 86th Constitutional Amendment Act 2002, which gave between 6 to 14 years for children free and compulsory education. It also changed the subject matter of Article 45 that between 0 to 6 years free and compulsory education is given under Article 45 DPSP, and it is called as dawn of the second revolution. Viju Patil, every day polity class is between 5:15 PM to 6:15 PM, 1 hour class. 1 hour class, Viju Patil sir. Jyoti ma'am, RTE came into force in 1st April 2010. Yes, Jyoti ma'am. Jyoti ma'am, I have already told you, in polity many act get passed in different date, many act come into effect different date. ಕಾಯ್ದೆಗಳು ಪಾಸ್ ಆಗೋದು ಬೇರೆ ಡೇಟಲ್ಲಿ, ಅದು ಜಾರಿಗೆ ಬರೋದು ಬೇರೆ ಡೇಟಲ್ಲಿ. ಸೇಮ್ ವೇ ವೆನ್ ಆಕ್ಟ್ ಈಸ್ ಪಾಸ್ಡ್, ದಟ್ ಈಸ್ ಪಾಸ್ಡ್ ಇನ್ ಸಮ್ ಅದರ್ ಡೇಟ್, ದಟ್ ಈಸ್ ಇಂಪ್ಲಿಮೆಂಟೆಡ್ ಇನ್ ಸಮ್ ಅದರ್ ಡೇಟ್. ದೆರ್ ವಿಲ್ ಬಿ ಎ ಟೈಮ್ ಗ್ಯಾಪ್. Jyoti ma'am, I hope you are understanding. So till here Article 21A you have learned, students. Article 21A entire is completed. Very simple article. From Article 21A only, free and compulsory education, right of our children for free and compulsory education under RTE Act 2009 was introduced. So 21A is completed from this. Let's see Article 22. Very important article. 22, very important article. What is the name of the Article 22? Title of the Article 22, if you see, it is protection against arrest and preventive detection. Protection against arrest and preventive detention. Article 22. Article 22 deals with two types of freedom. That is, one is your rights against arrest, your fundamental rights against arrest, and your fundamental rights against preventive detention. First, let's deal with fundamental rights under preventive detention. Yes, Diana ma'am. So, under detention, there are two types of detention. Under detention, there is preventive and punitive detention. Article 22 deals with detention and arrest. Fundamental rights of a person when he is arrested, fundamental rights of a person when he is detained. Two types of rights we are seeing under Article 22. First, we are dealing with what are the types of detention. First type of detention is a punitive detention. Punitive detention. What do you mean by punitive detention? Means punishing a person, detaining a person after the court case, after court case is done. Meaning a person has committed crime, ಒಬ್ಬ ಪರ್ಸನ್ ಕ್ರೈಮ್ ಮಾಡಿರ್ತಾನೆ, ಕೋರ್ಟ್ ಕೂಡ ಶಿಕ್ಷೆ ಕೊಟ್ಟಿರುತ್ತೆ, ಅವನ್ನ ಡಿಟೈನ್ ಮಾಡಿದ್ರೆ ಅದನ್ನ ಪ್ಯೂನಿಟಿವ್ ಡಿಟೈನ್ ಅಂತ ಕರೀತಾರೆ. When a person is detained after a court trial, after a conviction, it is called punitive detention. What is preventive detention? Another type, preventive detention. What do you mean by preventive detention? Means person is detained in order to prevent the future crime from him. ಯಾವ ವ್ಯಕ್ತಿ ಮುಂದೆ ಇವತ್ತೋ ನಾಳಿದ್ದೋ ಕ್ರೈಮ್ ಮಾಡಕ್ಕೆ ಹೊರಟಿರ್ತಾನೆ, ಕ್ರೈಮ್ ಮಾಡೋಕ್ಕಿಂತ ಮುಂಚೆನೇ ಅವನ್ನ ಅರೆಸ್ಟ್ ಮಾಡಿಟ್ಕೊಂಡ್ರೆ ದಟ್ ಈಸ್ ಕಾಲ್ಡ್ ಪ್ರಿವೆಂಟಿವ್ ಡಿಟೆನ್ಷನ್. ಪ್ರಿವೆಂಟಿವ್ ಡಿಟೆನ್ಷನ್ ಮೀನ್ಸ್ arresting a person, detaining a person before committing crime only for safety reason. Detention of a person without trial and conviction in order to prevent him from committing any crime offense in the future. So students, you might be wondering why have I put these photos here. So this is photo arrested. So 22, under 22, one of the fundamental right is against right of arrested persons. What about these two people? Today this person is a CM of a union territory. Now which CM, students? Who is he? Who is this person? Who is this person? Who is this person? This person is a present CM. ಇವಾಗಿನ ಹಾಲಿ ಮುಖ್ಯಮಂತ್ರಿ ಅವರು ಒಂದು ರಾಜ್ಯಕ್ಕೆ, ರಾಜ್ಯ ಅಲ್ಲ, ಯೂನಿಯನ್ ಟೆರಿಟರಿಗೆ, ಯಾವುದದು? ಸೊ this person is a chief minister of Jammu Kashmir. This person's name is Omar Abdullah. This person name is JKCM Omar. Yes sir, Sanhok. Yes sir, correct. Sanhok sir, correct. This person is Jammu Kashmir present CM Omar Abdullah. This madam is Mehboob Mufti. This ma'am name is Mehboob Mufti, and this person is Omar Abdullah. Why I have put their photo here is because some significant event happened in 2019. In 2019, on August 5th, I guess, students, one significant event happened relating to Jammu Kashmir. What was that? What was the significant event which happened on August 5th of 2019, students? Some significant event related to Jammu Kashmir happened. Whether in that these two people, why these two people related, I will show you why these two people are related to preventive detention. Because in August 5th, on August 5th 2019, abrogation of Article 370 and 35A. Abrogation of Article 370 and 35A happened in 2019, August 5th. During that time, these people, Omar Abdullah, Mehboob Mufti, these people were preventive detained. These people were house arrested because the central government, it thought that these two people will create protest, will create chaos, will spread misinformation, fake news among the people of the Jammu Kashmir. These people will create problem to them, thinking that union government, they preventively detained, they house arrested. So these two people were under preventive detention during 2019 August 5th. Not only these two people, all other local leaders there, in order to stop spreading misinformation, fake news, or creating any problem, protest, riots, to make the abrogation of Article 370-35A smoothly, these people were put under preventive detention, house arrested. Understood? I am giving you a simple example where preventive detention was used. So under preventive detention, there are two types of detention. Punitive detention, punitive is detaining a person after court trial. Preventive is preventing a person from committing a crime and detaining him before commission of crime. Now, what about a person who is arrested? Right of a person detained under ordinary law means a person who is arrested, meaning a person, police has taken him into his custody. What is the right of a person where police has taken him into the custody? If police has taken Bhandav into custody, if police has put Bhandav into jail cell inside the police station, inside police station also there will be cell, right? Inside police station there will be cell like this. So if Bhandav, police has put Bhandav behind the cell in the police station, what is the right of Bhandav? Let's see. What is the right of a person who is detained under ordinary law? First, police has to inform Bhandav why they are arresting him. The person who is getting arrested, he has to be told the reason on the grounds of why he is getting arrested. If police is arresting Bhandav, putting him in cells in jail, police has to tell me why they are arresting me. Next, the right to consult with a legal practitioner. Police should give me police should give me an option. I have the right to contact my lawyer. I will say, police sir, you can take me into custody, but you cannot snatch my phone. I have the right to call to my lawyer and tell him that please arrange a bail for me or come to the police station, they are arresting me. Diana ma'am, correct ma'am, correct, article 370, correct. So this is the second right of a person who is getting arrested under ordinary law. The right of to be produced before magistrate within 24 hours. This is third right. Police cannot keep anyone in the custody more than 24 hours if they are detained under ordinary law. If they are detained under preventive detention, then they can keep up to 3 months or more than 3 months. Without any preventive detention law, under ordinary law, if police is taking custody or arresting someone, within 24 hours, they should submit him in front of the magistrate. ನ್ಯಾಯಾಧೀಶರ ಮುಂದೆ ಅವರನ್ನು ಒಪ್ಪಿಸಬೇಕಾಗುತ್ತೆ 24 ಗಂಟೆಗಳ ಕಾಲ ಒಳಗಡೆ. ಅವರು ಅದು ಮೂಲಭೂತ ಹಕ್ಕು ಅದು. The right to be released is not, if not authorized by a magistrate. So, within 24 hours, the arrested person should be produced in front of the judge. If the judge tells police, this person is not done any mistake, please leave him, that person should be left. ನ್ಯಾಯಾಧೀಶರ ಮುಂದೆ 24 ಗಂಟೆಗಳ ಒಳಗಡೆ ನ್ಯಾಯಾಧೀಶರ ಮುಂದೆ ಪೊಲೀಸರು ಕೈದಿಯನ್ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಾಗ ನ್ಯಾಯಾಧೀಶರು ಈ ವ್ಯಕ್ತಿದು ಏನು ತಪ್ಪಿಲ್ಲ ಬಿಟ್ಟು ಕಳಿಸಿ ಅಂತ ಅಂದರೆ ದಟ್ ಆ ವ್ಯಕ್ತಿನ ಬಿಟ್ಟು ಕಳಿಸಬೇಕಾಗುತ್ತೆ. ರೈಟ್ ಆಫ್ ಅ ಪರ್ಸನ್ ಟು ಬಿ ರಿಲೀಸ್ಡ್ ಇಫ್ ದ ಜಡ್ಜ್ ಟೆಲ್ಸ್ ಈಸ್ ನೋ ಮಿಸ್ಟೇಕ್. I hope you understood. ಅರ್ಥ ಆಯ್ತು ಅನ್ಸುತ್ತೆ. 4 ರೈಟ್ಸ್, 4 ರೈಟ್ಸ್ ಆಫ್ ಅ ಪರ್ಸನ್ ಹೂ ಇಸ್ ಡಿಟೈನ್ಡ್ ಅಂಡರ್ ಆರ್ಡಿನರಿ ಲಾ. Now, there are exceptions, students. There are exceptions. So let's see what are the exceptions. ಏನಪ್ಪ exceptions ಅಂದ್ರೆ, these rights are not applicable to enemy aliens or person arrested under court order or preventive detention law. So obviously in previous class I have already told you, enemy alien yarappa? Who is enemy alien? Enemy alien is a foreigner who is from our country which is enemy to the Indian country. If any foreigner is from Pakistan, then he is enemy alien. If any foreigner is from China, China is our enemy, is enemy alien. So any foreigner from our enemy, India's enemy countries, these are all called enemy alien. So any enemy alien who is arrested and any person who is arrested under preventive detention, they can't get the rights under article 22. Any enemy alien arrested or any person detained under preventive detention law, they don't have right under article 22. ಅರ್ಥ ಆಗ್ತಿದ್ಯಾ? Not applicable. Yes Jyoti ma'am, not applicable. Now B. These rights are not applicable for arrest under court orders or civil arrest, arrest on failure to pay income tax or deportation of an alien. Obviously, when court has already given you punishment and you are arrested because of court, ನ್ಯಾಯಾಧೀಶರು ತೀರ್ಪು ಕೊಟ್ಟಾಗ ನೀವು ಅರೆಸ್ಟ್ ಆದಾಗ when judge of a court tells this person should be arrested and police arrest that person, now that person has no right to contact his lawyer, all these things, because already case is over, that person got punishment from the judge, so he is arrested. All this article under 22, no, all these rights doesn't apply for a person who is arrested because of court's order. Yes, Diana ma'am, yes, article 22. Article 22, Diana ma'am, it is not applicable only for citizens ma'am. There are also other type of alien. Enemy alien is one type. The second type of alien is friendly alien, meaning any foreigner from friendly country to India, meaning any foreigner from Russia, any foreigner from USA, any foreigner from Israel, any foreigner from South Africa, they are all friendly aliens. No, Diana ma'am, don't get confused, Diana ma'am. Only article 15, 16, 19, 29, 30. Only these 5 articles are only applicable to Indian citizens. But Diana ma'am, this is not applicable only for citizens. Article 22 is applicable for both Indian citizens and also to friendly aliens, but not applicable to enemy alien. Please understand. Don't get confused. So I hope you understood the exception, students. Exception, when a person is arrested, when an enemy alien is arrested, or when a person is arrested under preventive detention law, for him no rights under article 22. And when a person is arrested because of court order, when a person is arrested because he didn't pay the income tax, when a person is arrested because he is being deported, he is from some other country, illegally entered India, is getting deported, for all these persons under article 22, no, article 22, no rights are given to them. These are the exceptions. Any doubt, students? Diana ma'am, any doubts? Anhok sir, any doubt? Biju Patil, any doubt idya? Radha ma'am, doubt idya? Amruta Patil, doubt idya enri enadru? ಇಲ್ಲಿವರೆಗೂ ಏನಾದ್ರು ಡೌಟ್ ಇದೆಯಾ ನಿಮಗೆ? Any doubt, students, till now? I hope you understood article 21A. What is 21A? Article 22. Now, what are the, I told you, for person who is arrested under preventive detention law, for them no rights under article 22 because they have some other rights. Let's see what are the rights of persons arrested under preventive detention law. Article 22 talks about preventive detention and article 22 also talks about separate rights. There are separate rights under article 22 given to person who is arrested under ordinary law. There is separate rights under article 22 given for person who is arrested under preventive detention law. Sanhok sir, clear? Jyoti ma'am, okay, clear. Diana ma'am, clear. Radha ma'am, Amruta Patil ma'am, Basu LK, ಎಲ್ಲರಿಗೂ ಅರ್ಥ ಆಗ್ತಿದೆಯಾ ಕಾನ್ಸೆಪ್ಟ್? ನಾನು ಏನು ಹೇಳ್ಕೊಡ್ತಿದ್ದೀನಿ ತುಂಬ ಸಿಂಪಲ್ ಆಗಿ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡಿದ್ದೀನಿ. ಆರ್ಟಿಕಲ್ 22 ಕೆಳಗಡೆ 2 ಥರ ರೈಟ್ ಇರ್ತವೆ. ಒಂದು, ಯಾರು ಆರ್ಡಿನರಿ ಲಾ ಕೆಳಗಡೆ ಅರೆಸ್ಟ್ ಆಗಿರ್ತಾರೆ ಅವರಿಗೆ ಒಂಥರ ರೈಟ್ಸ್ ಇದ್ದರೆ, ಯಾರು ಪ್ರಿವೆಂಟಿವ್ ಡಿಟೆನ್ಷನ್ ಲಾ ಕೆಳಗಡೆ ಅರೆಸ್ಟ್ ಆಗಿರ್ತಾರೆ ಅವರಿಗೆ ಇನ್ನೊಂಥರ ರೈಟ್ಸ್ ಇರುತ್ತೆ. ಸೊ ನೌ ವಿ ವಿಲ್ ಸಿ what are the rights for that person who is arrested under preventive detention law. Now, right of that person to be informed the grounds of the detention, but if it is of public interest, if the matter is of ದೇಶದ ಭದ್ರತೆಗೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದಾದರೆ, if it's any public interest matter, national security matter, any very sensitive matter, no need to inform that person reason for arresting him. The authorities may refuse to disclose certain grounds if deemed determined to national security or public order. ಅರ್ಥ ಆಗ್ತಿದ್ಯಾ? If a person is getting arrested under ordinary law, ಒಬ್ಬ ವ್ಯಕ್ತಿ ಸಾಧಾರಣ ಲಾ ಕೆಳಗಡೆ ಅರೆಸ್ಟ್ ಆಗ್ತಿದ್ರೆ ಕಂಪಲ್ಸರಿ he has to be said the reason for arresting him. If the person is getting arrested under preventive detention law and the reason is sensitive national security or public interest matter, then no reason can be given. Now second right to consult a legal practitioner. Both, even the person who is getting arrested under ordinary law and also person who is getting arrested under preventive detention law, both people can contact their legal practitioner. ಸರ್ಕಾರ ಬಾಂಧವ್ ನನ್ನನ್ನು ಅರೆಸ್ಟ್ ಮಾಡ್ತಿದ್ರೆ ನಾನು ಕೂಡ ನನ್ನ ಲಾಯರ್ ಜೊತೆ ಹೇಳ್ಬೋದು, ಲಾಯರ್ ಜೊತೆ ಮಾತಾಡ್ಬೋದು. ಹಾಗೂ ಸರ್ಕಾರ ನನ್ನ ಪ್ರಿವೆಂಟಿವ್ ಡಿಟೆನ್ಷನ್ ಆಕ್ಟ್ ಕೆಳಗಡೆ ನನ್ನ ಅರೆಸ್ಟ್ ಮಾಡ್ತಿದ್ರೆ ಅವಾಗಲೂ ಕೂಡ ನಾನು ನನ್ನ ಲಾಯರ್ ಜೊತೆ ಮಾತಾಡ್ಬೋದು. ಐ ಕ್ಯಾನ್ tell my lawyer to apply for bail, or I can tell my lawyer to fight my case. Third right to make a representation. That's what right to make a representation means. I can be represented by my lawyer in the court. The lawyer, my personal lawyer, will fight for me in the court. That is what do you mean by right to representation. Right to representation ಏನಪ್ಪ ಅಂದರೆ ನನ್ನ ಲಾಯರ್ ನನಗೋಸ್ಕರ ಕೋರ್ಟಲ್ಲಿ ಹೊಡೆದಾಡ್ತಾರೆ. My lawyer will say that my client Bhandav has been held, my client Bhandav has been arrested under preventive detention law, so I am here to get bail for him. My lawyer will represent me. Fourth right, preventive detention laws cannot exceed 3 months. In terms of ordinary law, more than 24 hours it can't be. Within 24 hours, person should be produced in front of magistrate. 24 ಗಂಟೆಗಳ ಒಳಗೆ ಅರೆಸ್ಟ್ ಆಗಿರೋ ವ್ಯಕ್ತಿಯನ್ನು ನ್ಯಾಯಾಧೀಶರ ಮುಂದೆ ನಿಲ್ಲಿಸಬೇಕು ಪೊಲೀಸವರು. ಬಟ್ ವೆನ್ ಇಟ್ ಕಮ್ಸ್ ಟು ಪ್ರಿವೆಂಟಿವ್ ಡಿಟೆನ್ಷನ್ ಲಾ, ಯಾವುದೇ ವ್ಯಕ್ತಿ ಪ್ರಿವೆಂಟಿವ್ ಡಿಟೆನ್ಷನ್ ಲಾ ಕೆಳಗಡೆ ಅರೆಸ್ಟ್ ಆಗಿದ್ರೆ ಅಪ್ ಟು 3 months he can be in police custody up to 3 months without producing to him to the magistrate. In some cases that can also exceed. If more than 3 months is required, then there is one advisory board. In advisory board, retired judges will be there. Retired Supreme Court judges, retired High Court judges, Human Commission members irtare advisory board alli. So if the police want to keep that person in their custody for more than 3 months under preventive detention law, advisory board should give the opinion or give their permission to the police, telling that there is a sufficient grounds for the further detention for more than 3 months. Students, I hope you are understanding. A person arrested under ordinary law, he should be produced within 24 hours, whereas person who is arrested under preventive detention law, he can be in custody of police for more than 3 months also. For more than 3 months, advisory board will give permission to the police. So even for 1 year, for more than 3 months, how many days, number of days they want, they can keep him in his custody. Diana ma'am, yes ma'am, advisory board presided by High Court judge. Yes ma'am, in advisory board there will be retired jury members, some Human Commission members, some High Court judges, some Supreme Court judges, some retired judges, they will be there in advisory board. So students, under Article 22, Parliament has certain rights. Under Article 22, Parliament has certain rights. What rights Parliament has under Article 22? Let's see. Under Article 22, Parliament can say under what circumstances or what classes of cases a person can be detained for more than 3 months under preventive detention law without obtaining the opinion of the advisory board. ಎಂ ಸುರೇಶ್ ಕನ್ನಡ ಕ್ವಶನ್ ಮಾರ್ಕ್. ಏನು ಸರ್ ಕನ್ನಡ ಕ್ವಶನ್ ಮಾರ್ಕ್ ಹಾಕಿದ್ದೀರಾ? ಕನ್ನಡದಲ್ಲಿ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ನೋಡಿ. ಇಲ್ಲಿ ಆರ್ಟಿಕಲ್ 22 ಕೆಳಗಡೆ ಏನಿದೆ ಅಂದರೆ, ಯಾವುದೇ ವ್ಯಕ್ತಿ ಪ್ರಿವೆಂಟಿವ್ ಡಿಟೆನ್ಷನ್ ಕೆಳಗಡೆ ಅರೆಸ್ಟ್ ಆದಾಗ ಆ ವ್ಯಕ್ತಿಯನ್ನು ಪೊಲೀಸರು ತನ್ನ ಕಸ್ಟಡಿಯಲ್ಲಿ 3 ತಿಂಗಳಿಗಿಂತ ಜಾಸ್ತಿ ಇಟ್ಕೊಳ್ಳೋದಿಕ್ಕೆ ಬರೋದಿಲ್ಲ. 3 ತಿಂಗಳ ಮೇಲೆ ಪೊಲೀಸರ ಕಸ್ಟಡಿ ಆ ವ್ಯಕ್ತಿ ಇರಬೇಕಂತ ಅಂದರೆ ಅಡ್ವೈಸರಿ ಬೋರ್ಡ್ನ ಪರ್ಮಿಷನ್ ತಗೋಬೇಕಾಗತ್ತೆ. ಈ ರೂಲ್ನ ಯಾರು ಮಾಡ್ಬೋದು ಅಂದರೆ ಪಾರ್ಲಿಮೆಂಟ್. ಪಾರ್ಲಿಮೆಂಟ್ ಕ್ಯಾನ್ ಮೇಕ್ ರೂಲ್ ದಟ್ ವಿತೌಟ್ ಟೇಕಿಂಗ್ opinion of the advisory board more than 3 months also, police can keep a person in their custody. That law, that permission is given to the parliament. Parliament can make any law like that. ಪಾರ್ಲಿಮೆಂಟು ಪೊಲೀಸ್ ಅವರು 3 ತಿಂಗಳಕ್ಕಿಂತ ಜಾಸ್ತಿ ಕೂಡ ಒಬ್ಬ ವ್ಯಕ್ತಿನ ಪ್ರಿವೆಂಟಿವ್ ಡಿಟೆನ್ಷನ್ ಕೆಳಗಡೆ ಅರೆಸ್ಟ್ ಮಾಡ್ಬೋದು, ಇಟ್ಕೊಂಬೋದು ತಮ್ಮ ಕಸ್ಟಡಿಲಿ ಅಂತ ಪಾರ್ಲಿಮೆಂಟ್ಗೆ ರೂಲ್ಸ್ ಮಾಡೋ ಹಕ್ಕಿದೆ. ಯಾವ ಸನ್ನಿವೇಶಗಳಲ್ಲಿ, ಅಂಡರ್ ವಾಟ್ ಆಲ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸಸ್ ಅಂಡ್ ಕೇಸಸ್ ಆಫ್ ಕ್ಲಾಸಸ್ police or any person, any agency can keep them more than 3 months under the custody. That law can be created by parliament. Parliament has that power. Now parliament also has power to fix the maximum period for which a person can be detained any classes of cases under a preventive detention. So ಇವಾಗ ಎಷ್ಟು ಟೈಮ್ ಇದೆ? 3 months. The normal time is 3 months. Person can be arrested under preventive detention and held for 3 months. But parliament can create 4 months also, 5, 6, 7 or 1 year, 2 year, 3 year also. Parliament can fix the period to which a person can be arrested under preventive detention. Sanhok, yes. Yes sir. So now the actual time limit is 3 months for preventive detention, but parliament can make any number of period fixed for preventive detention. Parliament has that right. And parliament can fix the procedure to be followed by an advisory board in an inquiry. I already told you, advisory board is a board which is advisory board ಅಲ್ಲಿ ಯಾರಪ್ಪ ಇರ್ತಾರೆ ಅಂದರೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್, ರಿಟೈರ್ಡ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್, ಹೈಕೋರ್ಟ್ ಜಡ್ಜ್, ಹ್ಯೂಮನ್ ಕಮಿಷನ್ ಮೆಂಬರ್ಸ್, jury members ಇರ್ತಾರೆ. They do inquiry because why that person should be arrested for more than 3 months under preventive detention law? Is there any reason, genuine reason? ನಿಜವಾಗ್ಲೂ ಏನಾದರೂ ಅಲ್ಲಿ ಜೆನ್ಯೂನ್ ರೀಸನ್ ಇದೆಯಾ, ಆ ವ್ಯಕ್ತಿನ 3 ತಿಂಗಳಕ್ಕಿಂತ ಹೆಚ್ಚು ಕಸ್ಟಡಿನಲ್ಲಿ ಇಟ್ಕೋಬೇಕು ಅಂತ ಎಂಕ್ವೈರಿ ಯಾರು ಮಾಡ್ತಾರಂದ್ರೆ advisory board will do the inquiry. And advisory board, in what procedure they will follow during the inquiry? What procedure the advisory board will follow while inquiring? That will be fixed by the parliament. Jyoti, preventive detention law is still working. Yes ma'am, 100,000%, 10,000% preventive detention law is working. I already gave you one example. During 2019, repealing article 370, 335A, preventive detention was used. Present Chief Minister of Jammu Kashmir Omar Abdullah was arrested under preventive detention. Now also preventive detention is working, still used in India. And please note it down students, in the entire world, in the democratic country, India is the only country where preventive detention law is used. Please remember, even Britishers were using it. As we were ruled by the Britishers, we were colonized by the Britishers. Britishers used preventive detention. Same is borrowed in Indian Constitution. India is the only democratic country in the entire world to have preventive detention laws in its constitution. Jyoti ma'am, clear? So the constitution has not only given parliament the power but also state legislature to make any laws on the preventive detention. Students, In the previous slide, we learned what all power Parliament has to make laws on the preventive detention. But not only Parliament, also state legislature. ಭಾರತದ ಸಂಸತ್ ಮಾತ್ರವಲ್ಲ, ರಾಜ್ಯದ ಶಾಸಕಾಂಗಗಳು ಕೂಡ ಪ್ರಿವೆಂಟಿವ್ ಡಿಟೆನ್ಷನ್ಸ್ ಮೇಲೆ ಲಾಸ್ ಮಾಡ್ಬೋದು, ಕಾಯ್ದೆಗಳು ತರ್ಬೋದು. Not only Parliament can make laws on preventive detention, even state legislatures can make laws. You know, what are those laws? Let's see. Parliament has exclusive power to make preventive detention laws on the matters of defense, foreign affairs and security of India. Self-explanatory. When the matter is about defense, foreign affairs or security of India, only exclusively Parliament has the right to make laws on it. State legislature doesn't have rights. Please understand. When the matter is very serious, like defense matter, foreign affairs matter, security of India, the preventive detention law can be made only by Parliament on these topics, not by state legislature, because all these subjects are listed under Union list under Schedule 7. Under Schedule 7, all these topic subjects are mentioned under the Union list. So only Parliament has the right to make preventive detentive laws on these exclusively. Whereas on the topics such as public order, essential supplies and services, both Parliament and states can make concurrently. When it comes to the topic of defense, security of India, only Parliament can make. Foreign affairs, only Parliament can make. But when it comes to the topic like public order, essential supplies, both state and Parliament can together make laws on it. Understanding? ಅರ್ಥ ಆಗ್ತಿದೆಯಾ ಜ್ಯೋತಿ ಮ್ಯಾಮ್, ಡಯಾನಾ ಮ್ಯಾಮ್? ಸನ್ವಾಕ್ ಸರ್, ಆರ್ ಯು ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಿಂಗ್? ರಾಧಾ ಮ್ಯಾಮ್ ಅರ್ಥ ಆಗ್ತಿದ್ಯಾ? ಅಮೃತ ಪಾಟೀಲ್ ಅರ್ಥ ಆಗ್ತಿದ್ಯಾ? ಬಸ್ಸು ಎಲ್ಕೆ ಅರ್ಥ ಆಗ್ತಿದ್ಯಾ? Only Parliament can make laws on those subjects which are mentioned in the Union list, but on public order and essential supplies, both Parliament and state can make laws on the preventive detention. Yes, Jyoti ma'am. Okay. So, Jyoti ma'am, this is to you. Jyoti ma'am, you are asking, no, sir, is preventive detention law still active in India? Yes ma'am, these are the preventive detentions law currently active in India. Before this, there were many more laws, preventive detention, they are all deleted. As of now, there are 5 preventive detention law working currently present in India. Before this, there were other 5 detentive law. There are almost 10, but they are all deleted. See the 5 preventive detentive laws active in India. First is called as COFEPOSA. COFEPOSA. It is the Conservation of Foreign Exchange and Prevention of Smuggling Activities Act 1974. COFEPOSA. Those person engaged in the smuggling of goods, those person engaged in hawala smuggling, all those people are booked and arrested under COFEPOSA Act. This is one of the preventive detention act. Second one, National Security Act, NSA Act. That is also preventive detention law. Anyone arrested under these acts, very powerful acts, they won't get bail. Any people arrested under these acts. They don't get any fundamental rights also. Any people arrested under these acts. Next, third right, Prevention of Black Marketing and Maintenance of Supplies Essential Commodities Act. Those who are engaged into black marketing activities, artificially blocking supplies of the commodities, essential commodities, they are also arrested under Preventive Detention Act, that is Prevention of Black Marketing and Maintenance of Supply of Essential Commodity Act 1980. UAP Act, the Unlawful Activities Prevention Act, very powerful. All these days, recently all politicians are getting arrested under these acts. UAP Act, which was introduced in 1967 but amended 2004, amended lot of times. UAP Act amended lot of times. 2004, 2008, 2012, 2008 amended, but introduced in 1967. This is also one of the preventive detention law. And the fifth preventive detention law is the Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act, PIT NDPS Act 1988, which is persons who are selling, buying drugs, who are trading drugs, who are smuggling drugs, narcotic substance. All these 5 laws are preventive detention laws, very powerful laws. Whoever getting arrested under this law is not getting bail, is very powerful, is not getting any fundamental right also. Very powerful acts, laws, preventive detention laws. There were other laws also. Example, TADA Act, Terrorist Act. If you know Sanjay Dutt, students. Diana ma'am, you know Sanjay Dutt. Jyoti ma'am, Sanjay Dutt gotta? Bollywood actor Sanjay Dutt. Sanjay Dutt was arrested under TADA Act. Now it is deleted. Now iವಾಗ TADA Act ಇಲ್ಲ ಇವಾಗ. ಇದು terrorism activities ಸಂಬಂಧಪಟ್ಟಿದ್ದು. Those who are engaged into terrorist activities, now they are booked under National Security Act. But before, you know Sanjay Dutt case, right? Bollywood actor Sanjay Dutt case. TADA 1985, correct ma'am? TADA 1985, now it is not there, repealed. ಇವಾಗಿಲ್ಲ TADA Act. But when Sanjay Dutt, Bollywood actor, he was arrested under TADA Act, Terrorism Activities Related Act. Very powerful act, no bail, pakka jail. That act. Now it is not there. Like that, there are other 4-5 acts, now it is not there. Earlier there were many preventive detention acts, but now the number of preventive detention acts are reduced. Now there are only 5. India is the only democratic country to have preventive detention act. Usually no other democratic countries they have preventive detention act. One of the criticism for India is to have the preventive detention act. Yes, Diana ma'am, TADA Act, Terrorist and Descriptive Activities Prevention Act. Correct. So any doubts till now, students? We learnt Article 21A. Any doubt till now? We learnt Article 21A, right to education. We learned what did Supreme Court verdict say 1992-1993. We learned what is 21A. We learned what is 1993 Supreme Court verdict. We learned what is 86 Constitutional Amendment Act 2002. What did it give? 45 article. We learned 21A introduced also right to free and compulsory education, RTE Act, and how Swaran Singh Committee recommended fundamental duties through 42nd Constitutional Amendment Act 1976. There are only 10 fundamental duties. 11th fundamental duty was added. 86 Constitutional Amendment Act 2002. Then we also learned what is Article 22. Article 22 is ಏನಪ್ಪ? What are the types of detention? Preventive detention, punitive detention. What are the rights for person arrested under ordinary law? What are the exceptions? What are the rights for person arrested under preventive detention law? So what all power Parliament has to make laws under preventive detention? What all laws both Parliament and state have? What all laws only state have, only Parliament have? So we also saw what are the preventive detention laws active in India. Any doubt, students? Any doubt, students, till now? KPSC students, ಯಾರ್ಯಾರು ಇವಾಗ ಬಂದಿದ್ದೀರಾ ಕ್ಲಾಸಿಗೆ ಹೊಸದಾಗಿ ನೋಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಕ್ಲಾಸ್ ರೂಮ್ ಕೋಚಿಂಗ್ ಸೆಷನ್ಸ್ 5 months ಕ್ಲಾಸ್ ರೂಮ್ ಕೋಚಿಂಗ್ ಸೆಷನ್ just started, just 2 days before started, still in its orientation stage. ಸಿಲೆಬಸ್ ಯಾವುದು ಇನ್ನೂ ಸ್ಟಾರ್ಟ್ ಆಗಿಲ್ಲ, ಸಿಲೆಬಸ್ ಇನ್ನೂ ಕಳ್ಕೊಳ್ಳೋದು ಇಲ್ಲ. ಕೂಡಲೇ ನಮ್ಮನ್ನ ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಿ. ರಿಜಿಸ್ಟ್ರೇಷನ್ ಲಿಂಕ್ ವಿಲ್ ಬಿ ಇನ್ ದ ಡಿಸ್ಕ್ರಿಪ್ಷನ್. ದೇರ್ ಆಲ್ಸೋ ಫಾರ್ KPSC ಸ್ಟೂಡೆಂಟ್ಸ್ ಐ ವಿಲ್ ಬಿ ಟೀಚಿಂಗ್ ಪಾಲಿಟಿ, offline class polity in depth, in detail. You see all our faculties here. You will get 15,000 scholarship also and discount on fee structure also. KPSC students 5 months classroom coaching, admissions are open. Forward it to your friends also. Till now any doubt students? Doubt ಏನಾರು ಇದೆಯಪ್ಪ? ಜ್ಯೋತಿ, Diana ma'am, Suresh, Sanhok sir, Viju Patil sir, Radha ma'am excellent agbiಟ್ರಿ. Any doubt till now students? Any doubt? If we have come to the end of the class, Diana ma'am, thank you ma'am. Any doubt idya? Article 21A, Article 22. Article 21A, right to free and compulsory education for children age group 6 to 14 years. Article 22, right of a person arrested and also right of a person under preventive detention. Sanhok, thank you sir. Thank you sir. Diana ma'am, thank you ma'am. Jyoti ma'am, you studied preventive detention law was ended in 1969. No ma'am, not all laws ended. I told you Jyoti ma'am, before there were more than 5 laws. There were 10-12 laws. During some time later they were all deleted. Now present there are 5 preventive detention laws. These are the present 5 preventive detention law which is active in India. I hope you have understood our class, today's class. Tomorrow we will be studying, tomorrow students don't miss the class. Tomorrow we will be studying right against exploitation. Tomorrow students, tomorrow's class, rights against exploitation, Article 23 and 24. Article 23 and 24, right against exploitation. Tomorrow we will be studying about right against exploitation. Don't miss the class. 5:15 p.m. sharp. Thank you so much students. Namaskara, Tata, bye bye. Thank you so much for attending our class. ಮತ್ತೆ ನಾಳೆ ಕ್ಲಾಸಲ್ಲಿ ಸಿಗೋಣ ಈ ಟಾಪಿಕ್ ನೊಂದಿಗೆ. ಥ್ಯಾಂಕ್ ಯು.